Okay, so thinking now who you might wish to choose to be your attorney, you must appoint someone who has the mental capacity to make their own decisions. So for them to have the capacity to make your decisions, if you lose capacity, they need to currently have the mental capacity to make their own decisions at the time of appointment. If they were to develop their own difficulties in making capacitous decisions, you might wish to rethink and reapply with new attorneys or a new attorney. Sometimes you can set up a replacement attorney on the form if this should happen. You need to trust this person to make decisions in your best interest, because that is what they are supposed to do when you don't have capacity to make those decisions. And you have to be able to trust them, obviously, with things like finances, if you set up that can be used all the time. And also to consider, how happy is this person to make decisions for you? So you might think they make a great attorney, but do they actually want to take on this responsibility? Always best to discuss this with the person. Obviously they have to sign the form and agree, but it's good to discuss your wishes with your attorney or attorneys as you're setting things up, so that should they need to speak on your behalf, they know what your wishes are likely to be. So if we think about what it's like to be an attorney for health and welfare, a power of attorney is not properly registered and yours to use until it has come back from the Office of the Public Guardian. Just because it's been sent in, you usually need the copy to be able to show the hospital, for example. The Office of the Public Guardian are working to make this kind of thing easier, and I believe there's now a possibility of being able to share power of attorney online. So if you go to the website, that you should be able to say what organisations you want to share that with without needing to physically present a copy. And that seems to be a new thing they've introduced since COVID regulation. Obviously, going in person to present things became more difficult. You might need to make decisions about the donor's daily routine. So, for example, if they had to move to a residential home, you might be asked about what time do they like to get up, what kind of clothing do they like to wear, what kind of food do they like to eat, if that person's not able to say themselves. The most imminent call that may be made upon you would be for emergency medical care. So if the hospital knows that you have got lasting power of attorney for health and welfare, and the person has an accident or injury and is not able to tell the medical team what they want, you could be getting the phone call saying, the donor has been emergency admitted, we need you to say what their decisions would be on X, Y, and Z. On a more sedate note, the other end of a hospital admission, you might be asked about living arrangements. So whether the person would still wish to live at home, possibly with carers going in, or moving into a care home. So note if the donor has listed restrictions on what you can do and guidance on how they want decisions to be made, which can be added to the power of attorney document before it's registered. So looking at being an attorney for property and financial affairs, this covers things like money and bills, bank and building society accounts, property investments, pensions and benefits. Be careful to keep the donor's finances separate from your own, unless you've got a joint bank account or own a home together. If you do, tell the bank or mortgage company you're acting as the other person's attorney. Even with a joint account, I've heard that banks can. I've had one relative say, oh, the bank's got funny about it, but they've not actually stopped me from doing anything, but they've let me know they'll be monitoring sort of what I'm doing, even though it's a joint account. It didn't come to any particular difficulty, and the patient after a while was able to sign power of attorney here, so that was all resolved. But it was interesting to hear that even with a joint account, the banks can be potentially putting blocks on that or increasing the monitoring that they have of that account. You must keep records of ingoings and outgoings. So the Office of the Public Guardian and the Court Protection can ask to see these. There is a code of practice linked here, which I would recommend any potential or existing attorneys read, particularly chapters 1 to 5. I'm not sure if that's supposed to be and 16 or of the 16, are very relevant to the attorney for you to read. This code of practice is also about how you would know if the person who you are the attorney for, if that person, how would you gauge if they had capacity to make their decisions or not? Coming on to actually registering the lasting power of attorney, when you've made it, you need to register it with the Office of the Public Guardian. Just having the paperwork signed isn't enough. If you made your lasting power of attorney online, you may have registered it at the same time. It's registered when the OPG has stamped registered on every page. And last time I checked on this, it was taking between 8 and 10 weeks to register an LPA. If there are no mistakes on the application, they will send it back if there are mistakes. You can apply to register your lasting power of attorney yourself if you're able to make your own decisions. So now we'll come on to part 2, which is the specialist assessment of capacity to sign lasting power of attorney, called certificate providing. So we've talked so far about the person giving power of attorney, the donor, and the person who will be the attorney. But the third person involved, although there can be more than one attorney, is the certificate provider. So a certificate provider is an impartial person who confirms that you understand what you're doing and that nobody is forcing you to make a lasting power of attorney. They must confirm that you understand the significance of the lasting power of attorney. You have not been put under pressure to make it, there's no fraud involved, and they have no other concern. If possible, they should discuss your lasting power of attorney with you in private, without the attorneys or other people present, before they sign to certify their part of the lasting power of attorney. So basically, they are signing to say that you have capacity to sign lasting power of attorney, which, as we talked about, is potentially why it's sometimes important to get a specialist assessment for patients if their cognition and or communication have been affected after a brain injury. So who can be a certificate provider? They have to be at least 18 years old and either a friend, colleague, or someone you've known well for at least 2 years, not just an acquaintance. It can be your doctor or lawyer or someone with the professional skills to judge whether you understand what you're doing and are not being forced to make an LPA. So that would be where our specialist assessments come in. I don't need to have known the patient for 2 years to be able to do this, but I do need to assess their capacity if I'm going to certificate provide. People to notify can be certificate providers. You can list these on the form. There's quite a lot of people who can't be a certificate provider. There's a full list on the government website, but for example, members of your family or the attorney's families. So it can be friends, but not biological relatives. So looking at what someone with relevant professional skills means, it's usually one of the following: a registered healthcare professional, such as your GP, a solicitor, barrister or advocate, a registered social worker or an IMCA. And the Office of the Public Guardian say that if you want to use someone who has the specialist skills but is not on the list, you can contact them to see if that would be possible. So when thinking about certificate providing, whether it should be a lay person or a professional, I'm thinking why you might use a professional. I'll give some examples. So often what can happen is that lay people can be relatives or loved ones of a patient, might assume that they have greater understanding of what is being said than they do. So part of my job and the speech therapist job would be to assess that somebody is not doing the smile and nod and social niceties and behaving as if they understand what's being said when actually they don't, or they don't fully understand, or they've understood some of it but not other bits. So for example, imagine you have finally got away for a holiday in a foreign country where their language is not English. You get to the airport to fly home again and have gone to the correct departure gate waiting for the flight. An announcement in a language you do not understand or speak comes over the tannoy. Everybody stands up and gets in a queue to get ready to board the plane. What do you do? Probably at some point you are also going to stand up and join the queue, but you have understood what is happening based on the behaviour of the other people around you. You have not understood what was said over the tannoy. You've assumed based on environmental cues and others' behaviour. And so what we see on the wards is sometimes patients are extrapolating more of conversation using these kind of methods, and so it looks to their loved ones as if they're understanding what's being said, and we need to fully assess whether that is the case or not. The other end of the spectrum is, say somebody has expressive aphasia and they're not able to say what they want. It's our job to try to support them to communicate their wishes. We'll come on to the methods that we use for this. It may be that they need specialist help to demonstrate the capacity that they do have, because they cannot just say, yes, this is who I want, this is why I want them, this is why I trust them to do this job. We may need to use various card sort methods to allow them to choose who they want and to express why, and to express understanding of what power of attorney is.